Buckle up, because Judge Raquel West's courtroom doesn't play. This isn't your slow-moving TV courtroom drama. It's real people, real tension, and real consequences. Watch how she balances fairness with fire.
Good morning, you're Paul McCorvey.
Yes, ma'am.
And this is 24 DCCR 1914. Mr. McCorvey is charged with theft of property, and what is the announcement?
Just, it's taken a while, Claire, to get some things from a probate court, which we did by the last setting.
Right.
It was reset because we was trying to confirm restitution amount with the complainant. She won't talk with us. I think the issue is Mr. Hoffmeyer is going to try to get with the investigator, see if they can confirm an amount. Because basically the restitution was going to resolve the...
Right.
Correct, Judge, and the notes, according to Mr. Hoffbauer, are that based on that probate order, just a very short conversation with the complainant. Now we have that in the transcript, should get us to a figure that should be able to resolve.
Okay.
And I can make sure that...
If you would, because that's where I thought we were last time. And so if you'll get with him and make sure Mr. Hoffmeyer gets on that quickly so that we don't have another reset based on that, please,
I will,
ma'am.
Judge.
Thank you. All right, stay in touch with Mr. Lewis, and he'll let you know when you need to be back. Good morning, you're Ashley Sanders. This is 24 DCCR 1650. We were waiting on audit. Where are we?
What you're hearing sounds like just another case reset, but in legal terms, every reset is a tactical move. Prosecutors buy time to tighten evidence, defense lawyers stall to soften outcomes. Quick question, if you were the judge, how many resets would you allow before you said, enough's enough?
Judge, I'm happy to announce, thank you for the court being so lenient with us and resetting this a few times. Mr. Wimberly is actually here this morning with his client, my complainant. They did send me some documentation just right before docket. He's also indicated that his office is this week making notebooks for Mr. Kelly and myself and having everything scanned in. If we may just have one final, now that we have all that information, hopefully we can I can sit down with them, then Mr. Kelly and I can sit down and discuss it and see where we are. We'll be ready to finally announce next time, but I did want to confirm we do have all that documentation, or
Okay.
it should be to me this week.
All right. Thank you, Mr. Wimberly. All right, so what I'm going to do,
And if you want to go ahead and put it on the trial docket, Judge,
no.
I certainly would understand.
Yeah, no, I just want to, let's see.
My only concern when I hear notebook is...
That's what I'm
I don't know
thinking as
what
well.
we're talking about.
Yes, sir.
It'll be about that thick.
Okay.
It will all be heavy.
So why don't we do this? When we come back next time, I want it all done and I want an answer. And so what I'm going to do is reset it to the 1st of January. That should be about a 60-day, a little more than that. I want everything hopefully turned over this week. That gives you an opportunity. So unless there's something else that comes up, I want it all gone through in an announcement at the next court date.
Yes.
Okay? All right, you're free to go. Thank you, sir.
Thank you.
Thank you, Mr. Kelly. Morning, are you Ryan Hodge?
Yes, ma'am.
And Mr. Hodge is charged in cause number 24, DCCR 1167.
Did you catch that tone shift? That's Judge West giving what I call the gentle threat. It's a signature move, polite on the surface, but the message is crystal clear. Get your case in order, or next time, it's trial time. You can almost feel the temperature rise.
With the third-degree felony offense of evading arrest or detention with the use of a vehicle, the indictment alleges a prior burglary from 2015, and then also felony of bribing an officer in 2018 and possession of a firearm by a felon in 2018. We had reset that as well, some other stuff as well.
Those are out of state.
Yep. So what that means, though, is for punishment purposes, if Mr. Hodge, if you're found guilty by a jury, you would be considered a habitual offender, which means your minimum punishment, if you go to trial and are found guilty, is 25 years in prison, up to 99 years or life in prison. Do you understand? And we reset this case for you guys to watch the video, and have you had an opportunity to review the video in this case?
I've seen prior, like, version.
You've seen the video?
I think
Yeah,
he's
I've
seen
seen
it with his prior.
Okay,
previous
so you've
attorney.
seen the video, and have you talked to Mr. Kimmler about it? Answer out loud.
Do what, ma'am?
You've
Have
seen,
you
we've talked about the video.
Yeah, we've talked about it, yes, ma'am.
Okay, and I want to make
This next moment's brutal. Habitual offender status. 3 words that can change everything. In Texas, that means even if the crime isn't major, the punishment stacks. 25 years minimum. Imagine hearing that number while standing in front of a judge. What would you be thinking right now?
sure. So I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count 1 only, which is just the offense of evading arrest or detention, not those prior offenses, for a cap of 10 years, which means you would leave your punishment up to me. I can give you 10 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And do you understand all of that? And so I'm also making the notation here on that plea bargain rejection that I've admonished you as to what the minimum will be if you're found guilty, which is 25 years in prison. You understand? And you want to reject that and have your case set for trial.
Yes, ma'am. Didn't run, I was just speeding, driving.
He's maintained his innocence.
All right. Then I do want to make sure you understand that after today, I will not accept a plea agreement. I'll get your case set on the trial docket. There won't be a plea. We'll let a jury decide, okay?
So, for any reason, we can look into it further, the facts and the evidence.
Well, that's what a jury's for. And so your attorney has discussed the case with the assistant district attorney. Their position is that it's an evading and they think they can prove that, and that's what we're going to go to trial, okay? That's what a jury's for.
This is the crossroads every defendant faces. Take the deal or risk it all. Once you reject that plea, the safety net's gone. It's trial or nothing, and as the judge says, no more pleas after today. That's a one-way door closing.
All right?
Fire on the other. No.
All right, ma'am, you're Brianna Clanan. And will your client waive the formal reading of the indictment?
She will.
Ms. Clanan, in cause number 25, DCCR 0446, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from March 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimmler? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine.
I'll explain my scribbles, Your Honor.
Oh, that's CCCR. There would be
Yes,
a
there's
dismissal
miscommunication.
in cause number 25 CCCR 1119, and this will run concurrently with 25 CCCR
1053.
1053. Is that your understanding?
There should be another misdemeanor.
It was refused.
Oh, refused.
And what are those
The
cases?
dismissed one is resisting arrest, and they're all connected to this, Your Honor.
Mm-hmm.
The dismissal is a resisting arrest. The case to be pled is a DWI.
Okay.
All out of the same criminal episode.
Let me look at something real quick. Oh goodness, I can't see that. If I test you this morning, will you be clean?
Be honest.
Have a seat in the jury box. Have a seat in the jury. Have a seat in the jury box. Let's get you tested.
If the court is willing to accept it after the PSI.
Okay, and she'll waive the formal reading of the indictment in each.
Yes, sir.
So, Ms. Randall, in clause number 25, DCCR 06, you're charged with a state jail felony offense of theft of property with previous convictions. And that one's from November 21st.
Notice the shift again, from authority to concern. When Judge West orders an on-the-spot drug test, it's more than procedure. It's accountability in real time. Every case here isn't just about punishment, it's about second chances and how fast they can slip away.
1st of 2024. The indictment alleges you were previously convicted of theft April 4th of 1984 and April 11th of 1985, both misdemeanors, which would get us to the state jail felony level. It further alleges that you were convicted of a non-state jail felony offense of theft April 10th of 1989, and then again November 12th of 1991, and then after that was final, October 10th of 1994. And how do you plead to that charge? And are those prior offenses true? Or prior convictions true, excuse me. Are you entering your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? All right, give me just a second to get this pulled up so I can make that notation. I think that was 1 through 5.
Five or six, depending on how we want to look at it.